Welcome to Online Business Privacy 101 with us, DATATHENA. In this session, we're going to consider what you need to know to trade online lawfully. So, we're going to have a think now about what maybe you'll have commonly on your website, say if you're operating an e-commerce platform, and one of the things that you see very frequently is a privacy policy. And I don't know about you, but I've seen a lot that are copy and pasted around the web, and sometimes they don't actually cover what your business is processing, if they're lent from maybe a different source. And what they really need to do is to consider what data you're processing, why you're processing it, who you might share it with, and when you might need to disclose the information to other people. So let's just have a think about more of those in depth. What data are you processing? Well, say if I have a shoe business and I'm selling shoes online. The type of information I might process is credit card information if people buy the shoes. I might have their email address to let them know about their order or maybe to market to them. I might have their house address to make sure I get the products to them on time. And I might hold some other information, so say information about complaints or their particular preferences. So maybe you use cookies on your website as well, and you ask people to let you know maybe what they like about the website or not, or to share things on social media. They're all aspects of the type of data that you're processing. Which takes us on then to another really important question. What are you trying to do with that information? Well, as we said, say the banking information, we might be using that to process the bank transactions to make sure that we get paid for our products and that we know who to ship them to. So that's a relatively simple example of what we might be doing. We also might process it for analytics purposes, for example. So maybe through how people go on our website, we're using plugins and types of applications that let us know what people like and what they don't, and where they spend time on the site and what they're clicking on more frequently. And from that, we can get a better idea of what our customers like and maybe particular demographic trends. So, say what women like as opposed to men, what women aged 25 to 35 like as opposed to women who are 60 plus. It's all useful information that lets us know how to better serve our market. And then we have a think about who we might be sharing the information with. So, rarely in a business can you operate in a vacuum. You might share your information with the people who actually fulfill your orders. So, if you have a shoe business, for instance, you have to get your shoes from somewhere, unless you're making them yourself. Or you might buy handbags in, or even shoe boxes. These are all people who might actually have information about your clients or need the information in order to fulfill orders. You might even make use of a courier company to send out your parcels and packages, and they need to know information about the person who's going to receive the package. You might also need to disclose it for other reasons. So, say for instance, if you have appropriate marketing consents, which we'll look at later in this session, well, you might need to share it with them so that they can go and do their marketing. And that's another example of data sharing, which you might not have thought of just about thinking what you do on a day-to-day business level. And then you might need to disclose the data to other organisations. So say, for instance, if you're taking credit card payments and a payment doesn't go through or you think there's a fraudulent transaction, well, you might need to share that with the law enforcement agencies or with your bank to comply with your credit card rules that you might be subject to as a condition of making use of that payment process. And you might have to disclose it to law enforcement agencies. So, say for instance, if there was this fraud example, you might need to tell the police that you think a card's not being used by the person who's actually the recipient of the bank's services. So, you might need to share that information on. So it's important to make sure that you have a privacy policy in place. And if you have a look on the DATATHENA website, you will see that we have a number of examples of privacy policies that cover various processing activities depending on the size of your business. I would say it's a very good idea to have a look at your privacy policy now if you haven't done so already, because there's some new laws coming into effect in May 2018, from the 25th of May 2018, which cover data processing. And they're going to require you to have much more prescriptive processes in place with regards to your privacy policies and something called fair processing information. So what you'll need to have in place is a very descriptive example of what information you're collecting, what you're using it for, what purposes, and to make sure that you're only using the data in accordance with the consent of the individual, so the people going on your site or making purchases through you, for example. The real difference between the current legal landscape and the landscape that we're going to is that under the GDPR, you'll have a sense of purpose limitation, and you'll only be able to use information for the purposes for which it was initially collected. And if it's different, then you'll need to get new consents. So that's another sort of layer of challenge in terms of what you're doing with your policies. I would recommend to go and have a look at the GDPR compliant privacy policy. There's some more details of what it contains via the document shop, but it's extremely important that you have that in place because it's a very important cornerstone of compliance, especially for e-commerce companies. So it's something that you really do need to pay some attention to. And although May 2018 seems quite far away, it's rumbling along, and by the time you've got these things agreed and put them in place and you're happy with all the processing, it always takes a little bit longer than you think it will. So I'd recommend putting some time to it now. And we'll also be running seminars in GDPR and talking you through how to actually draft the documents yourself. So if you want to take advantage of those classes in a live environment with me, and I will talk you through how to put those policies in place and what you need to change to bespoke it to your business. That's something that we're going to be offering over the next coming months. And you can register your interest for those via the website. So moving on from those sort of processing requirements, the privacy policy also needs to consider if you're sending data overseas, if you're undertaking marketing, which we discussed before, if you're making use of cookies, which you might have covered in a separate cookie policy. It's important to set out what cookies you're using and why you're using them. Again, we have a really good document that you can use for that, which again, it's well worth your time looking at because it takes a lot of the legwork out of you having to figure out what you need to tell individuals about how to opt out of the use of cookies, manage their preferences, and what you need to explain about how certain types of cookies work. So say, for instance, temporary cookies or session cookies, as opposed to ones which gather much more data about the individual. And you also need to give a point of contact, and I think that's something most websites do anyway, but it's good to have this covered off in the policy because it helps people to just find their way around their privacy rights a little bit more easily. So now we're going to come on to this concept of consent and consider just in a day-to-day business why you might need to gather consent. Well, you might need it for marketing purposes. So in this sort of example of our shoe business, you might want to maybe send out a newsletter about great offers on shoes or 25% discounts or whatever offer it might be that you're putting in place in the future. Well, you'll need to make sure you're telling people that you're using their information for marketing purposes so that they have an opportunity to say that they don't want that to happen. That's something that we call, under the Privacy and Electronic Communications Regulations 2003, the soft opt-in. If you decide to share data with third parties for marketing purposes so they can go off and do marketing, so say your friend has a handbag business or you have a contact who is selling, say, luxury shoe cabinets and they want to market their services, you can't just pass the information over to that person or organisation. You have to make sure that you have express consent to do that, and the easiest way to do it is to have a tick in a box. And as you can see, there's a slight distinction there between the two methods of consent. One, you're offering the option to opt out for your own marketing purposes, but with the third parties, you need to have an express opt-in. Under the GDPR, the requirement for consent becomes a bit more stringent, and you have to make sure that you're giving people the opportunity to express their affirmative consent to marketing. So although the General Data Protection Regulation doesn't overrule those privacy and electronic communications regulations, if you try to interpret and reconcile the two, it's probably likely that you're going to have express consent for all types of marketing because the consent must be unambiguous. Another category of data where you might have to get express consent is for the processing of sensitive personal data. So that would include information like health records, criminal convictions, trade union membership, details about ethnicity, and all of those sort of types of things that we hold more sensitive to us. It's interesting to note that it doesn't actually cover things like banking data, or even though that's extremely confidential, it's not defined as sensitive. And just to give you a bit of a background as to why that's the case, it's for historical reasons about how privacy law developed. Privacy law, sort of as it's come to effect in Europe, really developed as a result of persecution and things like the Second World War, where you saw people persecuted for their beliefs and for their religion and for their status in society. And so they're seen as these very important categories of information to protect because they're something that's very inherent to who we are as individuals. And although banking data is very important, as you can see just from that explanation, it's not sort of inherent to your sense of self. So you might want to just take some care over that. If you're, say, perhaps providing online health-related services, or even if you're collecting information about job applicants that includes information about sort of their criminal convictions, for instance. It's very important to make sure you get express consent for that and lead people back to your privacy policy. And then we have credit-related activities. So say, for instance, you have a website that's offering a payments process, or perhaps online banking facilities. So there's apps now very popular that aggregate all of your information for you and tell you what's happening across all of your bank accounts and your feeds. If you end up taking credit reference related activities, so performing credit searches on individuals, for instance, to see if there's someone who you want to enter into business to, and if maybe they can afford, for instance, a loan that you're offering, or sort of a hire agreement or short-term credit, you need to make sure you're getting consent from the individual to process the data for those purposes. We are going to actually run a specialist session just looking at financial products and credit-related activities. I think it's something that's definitely worth having a look at in more depth because, again, the GDPR that we referred to does make some changes that make the law in this area potentially more procedural in terms of meeting your compliance outcomes. So if you're someone who's offering maybe credit-related products or hire products, or if you're operating in the fintech space, I would highly recommend that you sign up to our course on credit and the banking industry. There's plenty of information we can give based on our experience of acting with lots and lots of different banks that will help you to understand a bit better how to meet your compliance outcomes. And as you mentioned before on the consent point, we've got marketing here, and what we're just going to have a look at now in a bit more depth is the marketing points that we've spoken about in relation to consent. So for your own marketing, as we said, you need to get the soft opt-in, so give people an opportunity to opt out of their receiving marketing lists, and you need to tell them that upfront when you're seeking to get consent to undertake that type of marketing. With the third parties, as I said, you have to get express consent to pass it on, and under GDPR it's likely that you'll have to have consent for both. We do have precedent marketing wording that you can make use of, which you can find in the document shop, which again I think is quite useful in terms of just making sure that you're meeting your outcomes, because you also need to make sure you're placing your privacy policies in the right place and things. A course that we're looking to run in addition on marketing is actually looking at how you place the consent wording within the customer journey. So if you're running an app, for instance, or you have a website with more complex functionality where you're taking users through maybe a sign-up process and they're going through different screens in order to sign up to your product, I'd recommend that you sign up for our customer journey course, because in that course we're not just going to look at the legal aspects. What we're going to look at is how we can create a really great experience for your customer and try and get as much marketing information as we can and get people signing up to lists without falling foul of the law or creating attrition where people just don't bother signing up or they tick the no box. So we're going to have a think about how do we have to actually draft something that encourages people to engage with your brand and with your experience, rather than seeing it as something that maybe sits a little awkwardly within the process and feels a bit legal. And then we have buying marketing lists. With regards to buying marketing lists, it's something that companies commonly do. I think it's maybe a little bit less common practice now than it was, because there's a bit of concern over whether the data comes in what we'd call sort of a hygienic package, so making sure that it's all legally compliant. If you're involved in buying or selling marketing lists, I would just say just take some care over what you're doing with them, and do read the terms and have a look at what the buyer or the seller are offering. So in the example of the seller where you're buying in a list, you'll want to see that there are some sort of legal protections around if the list was received lawfully and in compliance with applicable law and data protection law, and it's compliant, and that the privacy policies and consents that we've talked about previously have been provided to individuals to make sure that the data is received lawfully and compliantly. And you'll also want to look for maybe a warranty or indemnity protection or some kind of liability provision, so more of a commercial term than a data one, to make sure that the list that you have purchased, if it just turns out that they haven't had the consents and there's a legal ramification for that for you, that you have some sort of recourse. This is very important because the Information Commissioner, who's our UK data regulator, has fined some companies recently who've been buying in lists and not paying too much attention to the provenance and the hygiene of the lists. Because at the end of the day, if you're using the list, then you're responsible for it. So it's very important to make sure you're dealing with data lawfully. And apart from anything, people getting random emails from you when they have no idea why you've got their sort of contact details can be frustrating for them. And again, everything that you should be doing with your marketing strategy should be to build up belief and confidence in your brand and a desire to engage with it. And that's, as I said, something we will definitely cover on that particular marketing course when we run that. If you're selling a list, you'll want to make sure that you've been as compliant as possible, but if you're asked to give certain warranties and indemnities in relation to marketing lists, you will need to pay attention as to whether you can assert with confidence that you have collected them lawfully. Otherwise, you might want to have a think about whether you can sign up to terms which potentially might lead to some sort of liability for you if something happened with that list in the future. We do have a very in-depth note on buying marketing lists, again, available via the website. So if you want to know more about buying marketing lists or take something back to your team, that's a really good resource to go to. And another aspect of sort of your business online might be whether you process data overseas. So we're just going to have a look at that now in more depth. Basically, anytime you process data outside of the European Economic Area, which is Europe and a couple of other countries, such as things Finland and Iceland and Norway, you want to make sure that you've got adequate protection in place with the information that's being processed. If you don't do that, you're not complying with the Data Protection Act for data transfer rules. So what are the ways that you can fix this? Well, if you're transferring data to the USA, you might want to check if the organisation that you're transferring the data to are registered under the Privacy Shield scheme. Or you could ask your outsourced service provider or the company if they're registered with Privacy Shield if they're in the US. And if they're not in the US, you'll want to ask them if they're in a country that has a finding of adequacy. So common examples of that are countries like Germany and Guernsey and where else can we think of off the top of our heads? The Channel Islands, for instance. So they all have findings of adequacy because they have a level of protection that's analogous to what we have in Europe. But I think sort of the nature of modern business, I think we'll all acknowledge, is that, frequently you're outsourcing to countries that maybe don't have the same data protection in place as Commonwealth countries and European countries. So thinking here, very commonly, there's lots of outsourcing to countries like India and the Philippines, which are outside of the EEA and are nor deemed to be mutually adequate countries. For those countries, you can go down a few different routes. You can adopt something called binding corporate rules, which is an international transfer mechanism for data between your controller and processor. I wouldn't recommend for most businesses that they're maybe the right fit because they're quite expensive to do and quite procedural and take a fair amount of time because you have to get them signed off by the regulator. Other routes is you can adopt a contract for data processing. We do have those available via the website. And thirdly, another way you could do it is to adopt the EU approved model clauses. Now, this is a precedent document, which means it's sort of a sample contract that you can adopt, and you can have confidence if you adopt it that you have a adequate transfer mechanism in place. You don't need to draft the terms yourself, they're all done for you, but it's a good idea to read them because they detail how individuals, if they suffer damage, can get some sort of recourse or remuneration from you or from the outsourced service provider. But you do have to fill in the back page that has some details of security requirements. So you'll say, for instance, what your security specifications are to make sure the data is kept safe and what data is actually being transferred. So in our shoe shop example, say we get the shoes from India and we're just doing some sort of drop shipping and all of the orders are actually facilitated out of our Indian company and transferred out. When we're sending over details, we might send over email addresses, customer addresses, name, date of birth, etc., in order to facilitate that order. So it's all important things there to make sure you're covering that Schedule 1. The good news is you can get a copy of these model clauses via our website, and they're completely free. So feel free to download those and make use of them for your overseas transfers. I'd recommend that you use that draft rather than the PDF version on the European Commission's website, simply because the PDF version isn't amendable. And the one that we've adopted is more in the style of a contract, so that you can fill in your own details and you don't have to put them in pen. You can do it on your computer electronically, send it over, and it's just a bit easier for people to deal with. So we've talked in general terms there about outsourcing and instances where you might do some outsourcing with your business. So in our simple example, we have the shoe company outsourcing to India. But now we're going to have a look in a bit more depth about what outsourcing means for a business. So what you have to do to comply with data protection laws is to make sure you've got in a contract that ensures that the organisation will put in place security measures and act on your instructions. Now, under the GDPR, things will change slightly and there are more requirements around what you need to do with data outsourcing, as it's not just the organisation who is paying for the outsourcing, so the customer, but the supplier as well will have legal obligations in relation to data processing, which they've never had before. They've only had sort of contractual requirements if the customer has imposed them. So that's a bit of a change, and it might affect actually liability provisions in contracts, because when both parties have to share the risk, inevitably that usually affects liability because they expect to have to share liability as well as part of that risk sharing arrangement. We do have a free GDPR webinar that covers the outsourcing requirements. So if you want to learn more about that, do feel free to go and have a look at that GDPR seminar, which gives you the whole rundown and what you need to be aware of with regards to GDPR. We'll also be running a course that will be a weekly course looking at issues in more depth, with more option to discuss GDPR with your fellow classmates who join the session with us, and to give you more insight about what other businesses are doing to meet the compliance requirements. So I'd recommend you sign up for that if you can. So we've covered what the bare minimum the law requires with that first point there, but there are a few other things that you would be wanting to look to do as well. To make sure that you can meet your compliance outcomes. So they're not regulatory requirements under the current law and not under GDPR necessarily, but you will, and we'll discuss those as we go along, but you will need to put these in place to make sure that you have some sort of control over the outsourcing process and, more importantly, managing your risk. So you'll want to make sure that your supplier deletes the data when the contract is over. Now, why is that so important? You may think the contract's over, the value's been realised out of it, or I'm not happy with that supplier, I've had enough of it. Well, your supplier could set up a rival business with your information, or they might start using the information to feed into their own analytics systems to understand customers better, and may start contacting your customers, for instance, which is something you may not want them to do, unless they seek permission to do that. So it's important to make sure that there's some management there. And obviously when a contract is over and the supplier's sort of received all of the money they can from you, they might not be applying the same sort of security and diligence around the information they're holding as they were when you were paying for those services. So you want to make sure the data is deleted and handed back so that you're reducing your risk of maybe a hack or a breach or an unauthorized disclosure of information happening. And that's just one common sense way to make sure that the security measures you're looking to have put in place unmet. And then we have restrictions on subcontracting. Now, under the current law, you don't necessarily need to restrict the subcontracting, but from a commercial perspective, it makes perfect sense because you're only as good as the weakest chain in your link. And say, for instance, the Indian shoe supplier decides to further subcontract to another supplier down the road at another factory. Well, unless you make sure that there's restrictions on subcontracting and that their subcontractor is subject to the same terms as you've put on your contractor, there's no means of you controlling what that subcontractor is actually going to do. And they could lose your information, they could act in ways that causes, data breaches or causes reputational damage to you. And in real terms, you've got no recourse for that. So what you want to do is to make sure that there's a flow down provision so that your contractors have to flow down the same terms that you've made them subject to. And secondly, that they remain liable for all of the acts of their outsourced service providers, so that if something does happen or that subcontractor goes under, you've got some sort of recourse to get money back from them. And similarly, you'll want to make sure that you have some sort of liability provision with the subcontractor too, so that if your contractor goes out of business, you've still got the ability to step into that subcontract and to sue them to recover your loss. Which comes on to the point about think about how you want to impose liability. If they're just giving you their standard terms, have a look and see, are there data processing obligations, and what does the liability say? Do they even have any liability to you? How are you going to get your money back if everything goes horribly wrong? It's really important to think about that. And with the overseas transfers point, as discussed on the previous slide, you've got to make sure that you have put restrictions in place on overseas transfers too, similar to what you have to have imposed on yourself, just to make sure again that if there's some sort of loss suffered, that you have this chain, this continuous chain, this unbroken chain of who is responsible for what in terms of compliance, and how you can seek recourse through liability provisions if the contract isn't performed in the way that you want it to be. I should note that with the subcontracting point under the GDPR, if you subcontract, you will need to make sure that you do have these flow down provisions in place. That becomes a requirement. Now, you can do flow down and insist they're subject to the same terms, or you can impose a right of veto. So you can say, generally you can outsource, but you have to make sure it's done diligently, and we have a right to say no if we're not happy, and you have to tell us about the outsourcing or change of contractor occurring before it takes place. Our GDPR compliant data processing agreement, which you can append to your outsourcing contract, or our standard clauses, which can be inserted into your outsourcing agreement, or even our letter, our formal precedent letter, which you can send on as a letter if perhaps you don't have this in place and you want to find a slightly softer way than a contract to make sure you get your providers signed up to these terms, all cover the GDPR requirements off. And as I said, the free webinar that we have, you can watch that, and it will give you some insight into what you need to do with regards to outsourcing. If there was one thing I was really going to, or maybe perhaps two things I was really going to strongly recommend after this session, it's to make sure you've got a data processing agreement, some sort of precedent, because you need to make sure you have those agreements in place. The fines under the Data Protection Act are £500,000, and they can restrict the way that you run your business as well. So they could say, for instance, you can't outsource, certain aspects of your business if that was deemed an appropriate enforcement outcome, or they might ask you to put in place certain new policies and procedures. Under the GDPR, the fines are very significant. You're looking at 2% of global turnover or €10 million, whichever's the greater, which are huge sums of money. Obviously, for most businesses, you wouldn't be fined in that range, but I think even for an average-sized business, a fine of, say, £100,000 is still a very significant fine. And of course, there's a lot of reputational damage that goes with that. So please do, after this session, think about your data processing and how you're outsourcing things, and think about your privacy policy, because they're probably two big areas of risk in your business where you need to make sure that they're covered off. So that concludes today's session. As you can see, I've just provided some links to things that we've talked about in the session. So do leave your comments in the bar below if you've got any questions, and we'll always endeavour to come back to them in our Q&A sessions where we round things up on the commonly asked questions. We have a guide to GDPR which takes you through it. It's completely free. You can download it at the website. The link's just there. As I said, we also have videos and webinars which are free. So feel free to make use of those and upskill yourselves on this area of law, because it's an important one and you do need to get to grips with it. If you want any further assistance with the types of services we offer, feel free to have a look at the website too. We explore those in more depth. And if you want to also download copies of those policies I've referred to, they're also available via the document shop on the site. And the free model clauses, which cost you nothing to download, are also available via there. So do take advantage of those. That's a really great offer, and you do need to have them in place. So if you do nothing else today, please download those and look after your business. And if you want to have our weekly newsletter, which keeps you up to date with what's happening with the law, case updates, and things that we think you need to be aware of or what you need to be implementing, please do click the link below and sign up.